Good morning, everybody. Thank you for joining us today. My name is Brian Waslu, and I'm joined by my colleague, Allison Lee. Usually when we host these HR review seminars, we do it with a lot of people in person in a large room, maybe a convention center or a hotel, and some breakfast. These days, of course, getting hundreds of people together is not in the cards, so we've taken our presentation to Zoom. The upside of this is that we had over 1,500 registrants. I'm sure people will continue to sign on. So we're happy to have you here with us on Zoom, and we do look forward to the day when we can spend some time together in person again. But until then, please keep well, and let's turn our mind to today's topic. Accommodation and human rights is always a difficult issue for employers to wrestle with. So Allison and I are going to try to help you this morning by picking out 3 particular areas where there's been some recent developments and cases that are of interest and hopefully assistance. So I will start off discussing disability accommodation, and particularly a couple of cases that really illustrate the need for an employee to cooperate and consider the accommodation efforts that are being made by their employer. So I'll look at an interesting case involving a commute to work. We'll talk about the distinction between a preferred accommodation and a reasonable accommodation, which is an important distinction. And lastly, I want to touch on an issue that's becoming more and more frequent these days, which are employees, as we're all returning to work now, someone who is frankly just afraid to come in or go downtown out of a fear of contracting COVID. And I'll pass it over to Allison, who will deal with family status discrimination, another issue that is a hot topic right now. What do employers have to do with respect to their employees' childcare issues and their childcare preferences? And how does COVID-19 affect that decision making? Also, an interesting question that I'll touch on, but Allison will flush out, is at the beginning and through the pandemic, as we've taken some flexible work arrangements or people have worked from home, what does that mean as we return to work? And some employees say, well, I want to stay working from home. Lastly, we'll return it to me, and I will talk about drugs and alcohol in the workplace, some recent cases on testing, and particularly important cases that put the focus back on the employer's responsibility to accommodate an employee who has a disability, and specifically what I'll be talking about is a substance abuse addiction. So without further ado, I will jump into the issue of disability accommodation. And before I discuss the cases that I wanted to raise with you, just a very quick refresher about, that's the slide I wanted, sorry about that, about accommodation and the way that that works. So when an employee asks for an accommodation, it's not every request that an employee makes that will trigger an employer's obligation to provide an accommodation. It's really a two-stage analysis. The first part is then broken down into 3 steps. And that first part is really the employee's onus to establish the need for accommodation. So first off, they're going to need to point to an enumerated ground. In this case, we're talking about disability, but that could be gender, sexual orientation, religion, any of those enumerated or read-in grounds. Secondly, they need to show an adverse treatment, which really just means a negative consequence. And that doesn't have to be direct and obvious. In fact, some of the examples that I'll talk to, particularly later on when we talk about drug testing and drug policies, is that a policy that seems neutral on its face might have a disproportionate impact. Someone who has a substance abuse addiction will have a harder time complying with that policy than someone who isn't. So there is an adverse impact, even if the employer meant well. And you need that causal chain. So in other words, the enumerated ground has a causal link to the negative impact or the problem. And I'll illustrate that when we talk about some of our cases. Then when that duty to accommodate is established, when there is that prima facie case, now the analysis switches over to the employer's obligation to suggest and provide reasonable accommodation up to the point of undue hardship, which is a terminology and phraseology that I'm sure most, if not all of you, have heard of. So the first case I wanted to talk about was with respect to a teacher in the Toronto District School Board. And this teacher fell and hurt her knee, and she had trouble commuting to work. The lesson from this case is about an employee's responsibility to engage and respond. Once the employer has offered a reasonable accommodation, the employee has to engage back, like, why doesn't it work, or give it a try. And that's not what happened here. Here, the griever fell in the parking lot at work, hurt her knee, so it was a WSIB approved case. And essentially the restriction meant that she couldn't drive for a long period of time. Her physician said it was 30 minutes. And initially the WSIB was helping her by paying for taxi transportation to and from her regular workplace, but those payments came to an end. She also said that she had difficulty using public transit because of stairs. That changed a little bit as the case went on. But the interesting part about this case is that there was no issue with respect to whether the employee could do her job. She could. It was strictly based on the commute. So first off, before I dive into some of those other issues, it's important to note that that was still within the concept of the disability enumerated ground that made it more difficult for her to report to her workplace. It's still in the wheelhouse of something that the employer had to consider with respect to an accommodation, notwithstanding it was commute-based. So there is no bright line, well, that's before work, that's before the work hour starts, so we don't have to worry about that as an employer. That's not the case. It's going to be factually dependent on each circumstance, and in this case, that wasn't the case, so they had to consider this. Now, where this case really got interesting was that the griever was refusing to break up her commute. So the regular reporting, the regular location that she would report to was beyond that 30-minute threshold. And she continued to assert that public transit wasn't an option, and she refused to break up her commute, take a break halfway through, get a coffee, or get out of the car and stretch. And she wasn't willing to do any of those things. The employer, on the other hand, was offering other school locations that, in the employer's mind, were reasonable accommodations. Some of them were 40 minutes, 50 minutes, but some of them were, in a bandwidth of 30 to 35 minutes. So just over this threshold that if we're being honest, the griever had chosen and her physician had endorsed. And it became pretty clear here that what the griever was doing was pushing for two particular schools that were inside 30 minutes, because these particular schools were on assignments. They were good jobs. They were almost like a promotion for the griever. And as this played out, the arbitrator really cut through that chaff and realized that in this case, we had an employee who was just pushing for her own preference of accommodations. So she was saying, well, school A and B are within my restrictions, and I want school A or B. And the employer, from their perspective, the school board was saying, well, A and B are, you could do those jobs with some improvement and training, but we have C, and that's within or close to your restriction, and you should try that. And she just refused to do that. So that didn't sit well with the arbitrator, and the fact that she wouldn't even try to break up her drive or try to mix it with public transit, or try this drive that was going to be 30 minutes plus a few minutes. The concept, again, that medical restriction could be so precise that 30 minutes was the hard stop and 32 minutes wasn't going to work, I think the arbitrator had a problem with, and frankly went so far as to say that they believed the griever's family physician was a bit of an advocate, as opposed to really tackling what the situation needed. So the principle is that an employee might have a preference, an employee might have their own idea of what might be perfect accommodation, but that's not the threshold that an employer is held to. The employer has to suggest something reasonable. They did so here. The arbitrator even mentioned again that the griever should have tried it, should have given it a try. I think don't take that too far, because every case it will be important to consider that we're not going to put someone in an unsafe situation. But here, the griever, the employee, was just sitting back and wanted what she wanted, and she wasn't engaging on a reasonable basis. And so she lost her case because of that. Similarly, another case with respect to preference versus, or perfect versus reasonable accommodation is illustrated in Tone and Canada Post. So this one is even more of an example where an employee just sits back and says, bring the accommodation to me, no, 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 without explaining why the accommodation offered by the employer wasn't going to work. So they have to do the best they can to raise their issues and to explain those to the employer so the employer has something to work with. In this case, the employee was a delivery agent, and ultimately he was terminated because he wouldn't report to work. What happened was the employee and his wife broke up. It was acrimonious. It was bad. The wife was also an employee of Canada Post. And so immediately after that friction and tension, from the griever's perspective, the complainant's perspective, he was beset upon. People were picking on him. People viewed him as the bad guy. Harassment complaints started to come in against him where employee X, Y, and Z see him talking to another employee inappropriately. So this is all beating down on him from his perspective. He files a harassment complaint back against his supervisors and managers saying that they're picking on him, they're harassing him, they're pursuing these frivolous allegations. And so he said that he needed to be accommodated. He certainly had anxiety and depression. Those were diagnosed and supported by his medical. His claims around sex and marital status was really stuff around the edges about, you're treating me poorly because I'm divorcing my wife, and that fell by the wayside. This case was about the mental impact and the depression that he was suffering. So what's interesting is if you look at what the medical said in that case, so his doctor is saying to the employer, well, this gentleman can't work because he has a fear of harassment. So he's afraid of being harassed, and he cannot work. So this is the direction of the employer. He can't work unless the harassment issues are resolved. He could do modified work as long as it does not adversely impact his recovery. Well-intentioned, but not terribly specific. And in my suggestion, not very helpful to an employer as to what exactly that means. So the employer did what it felt was best, and it proposed an alternate route. So the employee would work out of a different depot where the same supervisors and managers were not present. So in the employer's mind, that was removing him from the harassment. Now, he didn't want to report to that. He didn't provide any more medical to explain the situation, and so he was terminated. He was terminated. He filed a complaint with the Canadian Human Rights Commission, and he alleged that it was discriminatory on the basis of his disability. Again, the sex and marital status stuff fell by the wayside. The commission dismissed his complaint, and the employee then appealed to the Federal Court of Canada. So it went up from there. And the federal court looked at it. They also dismissed his case. They dismissed his appeal. So the basis on which they did that is they went back to the concept that an employee is entitled to a reasonable accommodation, not their perfect or their preferred accommodation. And the employee here was free to communicate problems that he had with the proposed accommodation. In other words, report to this other depot and do a different route. Now, when it got all the way to the federal court, past the commission and now at the federal court, things did start to surface. Now the employee was saying, well, the location wasn't very good, and it was kind of like a demotion. And now his response to, well, can you explain this better? What's the problem? I don't think this helps, but I'm going to read it to you so you can make your own opinion. But this was the way it was expressed now. This employee needed you, being Canada Post, to communicate with him in a manner capable of fostering trust and quelling his deeply held and debilitating anxiety-based suspicions about the malafides of Canada Post's intentions. If I tried to summarize that, it's sort of, you know, I guess they were saying you needed to have a sit down and a feel-good session and sort of make amends and repair the relationship. That had not happened. But the federal court said, you know, the time for raising all of these issues, for putting more explanation in and illustrating the issues you have with the accommodation proposed by the employer, was when that happened. It wasn't years down the road when the case was at the federal court on appeal from the commission. So they even went further than that. And they said, you know, you didn't provide that information at the time. It wasn't supported by medical either, which would normally be part of that. And it's not the employer's responsibility in those circumstances to pull everything out of you. the employer made a proposal that seemed on its face reasonable to address the harassment. You were moved out of the situation, and you didn't indicate why that wasn't going to work, and you didn't indicate or provide medical as to why that wouldn't work. You just kind of shut down. And again, the court was very clear, you have to try to do your best you can to illustrate your issues and why this isn't going to work. And he hadn't done that, and so lost his case. So the other issue that's now we're seeing more of, and it's a bit of a pivot, but it does go to this issue of the responsibilities on an employee to establish their case. So we just talked about two cases where the employees weren't participating in that accommodation process. And now we're going to talk about where it all starts. So we can do that in the context of the current COVID-19 pandemic. And we have employers who are having to respond where there's employees who have just a general feeling of worry or fear of contracting COVID-19. And so they don't want to come to the workplace or come downtown. And the bottom line is that with respect to an accommodation situation, and Allison will talk about family responsibilities and where unpaid leaves might be accessible under the Employment Standards Act, in an accommodation analysis, that employee is not entitled to an accommodation unless they meet that those first three parts is before we get to any accommodation analysis. And that first part was an enumerated ground. So this employee is going to have a medical condition, or they're in a particular risk group that puts them in a different circumstance that makes returning to work and exposure to COVID or contracting COVID a different calculation and a higher adverse impact upon that employee before you might have to move into an accommodation analysis. Another possibility is family status, but I will leave that to Allison. So if they have established that need, only then does the employer then have to look at accommodation. And in the context of COVID and not wanting to come to work, you might first look to your workplace. Okay, well, is there a way to do this job where they're not going to be in contact with anyone, or there's going to be a lot of distance and all the sanitization stations and all of that good stuff? It could be that that still won't do it because of their risk group or the particular circumstances of that employee. And you might have to look at a work from home arrangement. You know, what can be done working remotely. I think that's also where the concept comes in of what has happened during the pandemic. So you just have to bear in mind that, you know, as much as many employers did in permitting employees to work remotely from home, that is going to be some evidence of what is possible in terms of an accommodation. So if that circumstance has changed and you can explain why the business needs are different now, then you might have a different analysis to establish an undue hardship. Otherwise, you might have to consider letting that employee work from home. Just remember that when you're engaging in all of those analysis, as we've seen from those other cases, and it was a principle that we've had, employees are entitled to a reasonable accommodation, not their preferred or perfect accommodation. So to wrap up the section on disability accommodations, a few of the takeaways are that as an employer, you need and you shouldn't hesitate or don't hold yourself back from looking for clear and meaningful medical information. If you get medical information that isn't clear, it doesn't help you, do the best you can. The Canada Post case is a good example, right? So they took a rather vague medical situation and did the best they could. They said, well, let's move him out of the situation where his harassers are present. And if there's any other problems, then that should have been followed up with by the employee. It's often the employer that is going to be the one who's in the best position to know what the different options are and to make the different proposals. And in fact, it falls to the employer to make that proposal. But I think we've seen from those two cases I just spoke of as good examples, the employee also has an obligation to sort of participate reasonably once that proposal has been made and further proposals are made. They can't just sit on their hands and say, no, not good enough, no, not good enough. There has to be a why, and there likely has to be medical support for that. And that's really the last point, that the employee has an obligation to participate in the process and be flexible. So I am going to pass it off to Allison to talk about family status and accommodation.
Well, thank you, Brian, and good morning, everyone. So when we're talking about family status accommodation, we're going to talk about a couple different elements. First, as Brian did, we're going to start with a brief synopsis of the applicable test. Then we're going to talk about some of the new case law that's important to keep in mind. And lastly, we'll talk about all those COVID-19 considerations, considering family status is one of the big ones we see a lot of questions about these days. So to start with the test, and Brian's already gone over this, so we won't spend a lot of time on it, but we've repeated the point twice because it's important. Not every request for accommodation triggers a duty to accommodate. So every analysis should be done on a case-by-case basis. Does this request for accommodation trigger a duty to accommodate? And when you're looking at that, you're again asking those same questions that Brian went through. First, is there the existence of a protected ground? And when we're talking about family status, it's interesting because in Ontario, that means simply the parent-child relationship. That is the definition of family status. Now, if you're working in a different jurisdiction, it might be slightly different, but that's also what we're going to be focusing on today because it's the one we see a lot of when it comes to COVID-19. It's that parent-child relationship. Secondly, is there adverse treatment? And thirdly, is there that nexus or that connection in between your parent-child relationship and the adverse treatment? If the employee establishes all three of these elements, then we have to look at the duty to accommodate. And we have to ask, okay, can we accommodate this employee? Remembering that the bar or the threshold is that it's possible if it doesn't cause undue hardship. And we're going to discuss that a little bit more, but remember it's not a low bar for employers to meet. So the first case we're going to discuss is Canada Border Service Agency, which was a fairly recent 2020 case, and just really does deal with this issue that accommodations based on need, not preference of the employee. So it's an interesting case because the griever had been based in, and I apologize to everyone from this location because I'm probably going to mispronounce it, so apologies if this is your hometown, but she was based in Coutts, Alberta, and she wanted to transfer to the Edmonton International Airport location of the CBSA. And so she goes to her employer and she says, I want to transfer, please. It's an accommodation issue. And the reason she was saying it was an accommodation issue was because she was a single parent. And she said, I have extended family in Edmonton, and I need to be close to them in order to get appropriate childcare. Now, part of this was that she said she couldn't find suitable childcare in Coutts. And that was a really interesting thing because she said, okay, I'm working shift work for the CBSA, for example, so I just can't find childcare as a single parent in Coutts, and I need to be close to my family. So CBSA looks at this and says, we're not going to transfer you to Edmonton. We're denying that accommodation request. So the really interesting part of this case was that the griever had actually moved to Edmonton already. So when she went on maternity leave, she moved to Edmonton and was found to have had no intention of ever moving back to Coutts, which obviously was a big portion of the decision, because had she really made a good effort to try to find childcare in Coutts? The board said she hadn't. So she had said she'd done a thorough search, she'd looked all through Coutts for childcare, but the employer turned around and said, but hey, here's the thing, we're not prepared to transfer you, but we'll give you a fixed schedule, because one of the things you mentioned was that it's really difficult for you to find daycare that's flexible enough to deal with your shift schedule. And the griever hadn't accepted that, and as the board found, she hadn't done a really thorough search for daycare options. And the employer was smart. At the hearing, they brought in a bunch of their Coutts employees who'd had children and had them discuss childcare options. And it was fairly clear to the board that there were some, maybe not, again, her preferred childcare, which was family, But with the accommodation offered by the employer to put her on a fixed schedule, she certainly could have found something. So the grievance was dismissed, and they found that the employer had been completely reasonable, which really does highlight that when it comes to childcare preferences, again, a parent employee is not entitled to what they necessarily want. It's what they need. It has to be a reasonable accommodation, not the necessarily preferred or perfect accommodation. Second case we're going to talk about is Peternel and Custom Granite, which was a 2019 case from Ontario. And this one's particularly interesting because the question is about temporary accommodations. If you grant a temporary accommodation, the courts found it does not contractually bind you in the future. So what had happened was Peternel was employed as a scheduler. So after 6 years of this with Custom Granite, she claimed constructive dismissal and discrimination on the basis of family status. What had happened was that back when she started 6 years ago, she was advised by Custom Granite that she should be at work by 8:30 because that's when they needed their scheduler in. And Peternel said to Custom Granite, well, I can't be in for 8:30. I have, at that point, 2 children and I have childcare obligations. So I just can't be in by 8:30. And Custom Granite sort of gave her some leniency. She frequently did not arrive at 8:30 and generally, in fact, didn't usually show up till about 10 a.m. What happened then, though, was that she took maternity leave for her 3rd child. So she goes off on maternity leave and she has her 3rd child successfully, and she's looking to return to work. So she meets with Custom Granite and says, you know, I'm ready to return to work at this point in time. While she had been away on maternity leave, Custom Granite had done some restructuring and taken a look at operational demands. And so when they meet with her, they say to Peternel, here's the problem. Because we've been doing some restructuring and looking at our operations, we need our scheduler in at 8:30 a.m. in order to properly function. Peternel doesn't like this. And she says, well, I've got 3 children now, and I can only come back from 10 a.m. to 5 p.m. And more to the point, she says, those were the hours you allowed me before I went on maternity leave. That accommodation should maintain, and I should be able to work just 10 a.m. to 5 p.m. Basically, you owe me that, or you have to do that. So Custom Granite was in a bit of a bind and says, here's what we'll do. Why don't we offer you a different position with comparable salary, which is key, and the hours of 10 a.m. to 7 p.m. And that will allow you to accommodate your childcare obligations. But Peternel doesn't agree to this. She said, you had me as a scheduler prior to my paternity leave, working the hours to 10 to 5. I should be allowed to continue that. And if you don't continue that, as she eventually claims, I am being constructively dismissed and you are being discriminatory based on family status, namely that there's adverse treatment of me based on my status as having 3 children. What was critical here was that Peternel could not or did not give reasons why she could not have secured before school childcare. She just says that she didn't have any. And this is important to note because the court carefully and made a clear point of stating, well, Peternel had after school care. So why couldn't she find before school care? And because there was no clear answer to that, it was a serious problem for Peternel's case. So the court says, we are dismissing your claim. We don't think there's any merit in it, Peternel. And she appeals to the divisional court, and the divisional court also dismisses it. So the courts affirmed that the requirement that she start at 8:30 a.m. was not, in fact, discriminatory. There was a couple elements to this. First of all, they find that Ms. Peternel could not point specifically to evidence that there was adverse treatment. Again, that there was some sort of unfairness or, bad problem that was caused by this requirement that she be at work at 8:30. And as you might recall, part of that's, of course, of why couldn't she find before school care? was there something that was preventing that? And she hadn't provided any evidence to show that there was some sort of unfair or problematic treatment there. Secondly, she couldn't prove that nexus or link that we had talked about, namely that the adverse treatment and the protected ground must be connected. So since Peternell could not show that her family status had caused adverse treatment, there was no discrimination. The second point, as we mentioned already, is that Custom Granite's leniency in start times prior to her maternity leave did not form a contractual obligation that could be held against it. So Peternell was not entitled to say, you allowed me this leniency before my maternity leave, you have to continue to allow me this accommodation. So when you are providing a temporary accommodation, it's important to consider that it is not necessary that maybe you keep the accommodation if the circumstances have changed. And that was the case with Custom Granite. So we are now going to talk a little bit about COVID-19 because I think bar anything else, the most number of questions I'm currently getting from employer clients is, I want my employees to come back to work on a rotating basis or on a permanent basis or some other basis that allows proper spacing. And I am getting employees telling me that they have to stay home to take care of their children. What do I do? Because schools and daycares are now open, but you've got a lot of employees who are going to be saying, I can't juggle, schooling my child from home, I need to work from home, or I need paid time off to facilitate remote learning and or childcare. So it becomes a question of what happens when an employee comes to you and says, I need to stay home and you need to provide me an accommodation due to family status issues. There's a couple considerations, and where we have to start with this type of consideration is the Employment Standards Act 2000 infectious disease emergency leave. This is very critically an unpaid leave. So an employee is entitled and eligible for it if they need time off to provide care and support to a prescribed family member, which includes their child, for a reason related to COVID-19. The Ontario government has confirmed this includes if the parent chooses not to return their child to school. So when you have an employee comes to you and says, my child's school says they can either come back to school or they can stay home and do remote learning. I have chosen remote learning and I need to be home in order to facilitate that. They may have access to this unpaid leave. Now, very critically, of course, again, this is usually not the accommodation people are asking for. An unpaid leave is something they might be entitled to, but usually employers are saying, well, I'd like to work from home, or I'd like a paid leave, or I'd like different hours, or something like that. It's usually the work from home one that we see. So when it comes to a request for paid accommodation, this doesn't fall under the infectious diseases leave. Instead, this is the same as any other human rights accommodation request. So this is the same as somebody in either one of the cases we talked about who's requesting a family status accommodation. Just because it's due to COVID doesn't mean it's actually treated differently when it comes to this type of accommodation. There are a couple of questions we automatically have to ask though. The first one, and you'll see this has been a theme throughout, is this a need or is this a preference? Now, a need might be the situation where you've got an employee who says, my child has such and such a medical condition and therefore cannot return to school because it will put them at serious medical risk. A preference might be that person who says, well, my child's school reopened and I don't want to put them back into that school. I want to teach them from home. So in order to determine whether it's a need or a preference, first of all, of course, you can ask about it, and you should ask about it. There should be no hesitation to ask under these situations. And you should also be asking for supporting evidence. If the child has a medical condition, we want to be knowing what type of medical condition and what actually are the requirements? Because actually Brian had talked about that a little bit with one of the employees who said, I can't drive for more than 30 minutes. What are the details of what that child really needs? Because sometimes it might be the doctor says, well, the child should wear a mask, but is otherwise perfectly fine to go to school. And other times it will be the child cannot go to school physically, it has to be done remotely. So once you've assessed whether it's a need or a preference and what is the actual situation and the medical evidence to support it, then you're also going to be looking, are there other supports to provide childcare during the day? So, your employee wants to work from home. Do they have a co-parent? Do they have other family members that they might be looking into to have child support? Are there other systems in place? Does their school have, a half time where the child goes in the morning and doesn't go in the afternoon? Are there other things than just a straight up work from home that might be at issue? And we're going to talk about that a little bit more because, of course, that's also the question when it comes to what does the duty to accommodate look like. So if the duty to accommodate is triggered, so there is a need, not just a preference, there is support for that need, and it's not just a preference, and you've checked out whether or not there are other supports, like do they have a co-parent who works from home, in which case maybe your employee also doesn't need to work from home and there is no duty to accommodate. But if the employee has met all those requirements, then remember, you have an obligation to accommodate to the point of undue hardship. So undue hardship must be more than mere inconvenience to you. So I get a lot of employer clients who are calling me and saying, Allison, I just don't believe that my employees, quite frankly, work as well at home. Some of them need more supervision. The problem is that's not necessarily undue hardship. Some hardship on the employer is expected when you're accommodating people. It has to be to the point of undue hardship. And what might that look like? Well, maybe you have an employee who can't do their job from home. If you've got carpentry employees who are working on building a house, they probably can't do that from home, right? Or maybe you have other systems or requirements that mean that they can't work from home all the time. The key aspect, though, is also that each accommodation assessment is an individual assessment. It's not an employee comes to you, proves that they have an accommodation need, and then they all get the same accommodation. Because we want to be as creative and flexible as possible. Maybe you're looking at something like, can they work for flexible hours? Can they work from home during those mornings when their child can't be in the classroom? Does their child's illness have a cyclical nature so that if they're having a bad asthma season or whatever the case may be, they do need to stay home and otherwise they can come back to work? Because again, remember, as we saw in the case law, an accommodation can be temporary as well. It doesn't have to be permanent. And if they have other family members, are we talking about moving them, with a couple of family members and their children so that your employee only needs to work from home 2 days a week, for example? These are all things you want to be considering. And you might also be considering, can that employee do a joint work from home and then take the far office that's secluded on itself so it reduces the risk for their child? So a couple of takeaways with regards to family status accommodation. First of all, you want to remember that you have the right to request information about the employee's personal circumstances and why accommodation is being requested. I completely understand why people hesitate sometimes to ask for it, but when it comes down to human rights accommodation, you do have the right and certainly should be asking. Secondly, and I know we've repeated this several times by now, but it's an important point, the employee will need to establish that the adverse treatment is a result of family requirements, not their childcare preferences or personal choice. And I'm just going to note here, some of the things we've been seeing is that especially when a vaccination comes into play, if that becomes a 2021 issue, this might be something, again, you're having to consider. If somebody doesn't want to vaccinate their child, is that personal choice? Is it medical necessity? And can that child go or not go back to school? Lastly, accommodation may be required if the situation would result in a real disadvantage to the parent-child relationship, or, and this is the critical one, put a parent in the position of having to choose between working and taking care of their child. So, for example, if the parent is working, the child is and taking care of their child. So that's the one you want to watch out for. If it's really going to stomp them and they're going to have to either choose to work or give up their work to childcare, then you've probably got a situation on your hands where we need to be talking critically about accommodation. Now, I'm going to turn this back over to Brian now to talk about drug and alcohol testing.
Exciting. Thank you, Allison. Just a quick comment. People have found the Q&A box, which is great. There are a lot of questions. So we will continue the presentation until about 10 o'clock, maybe a little bit over, and then we will do our best until 10:30. We'll answer as many questions as we can. If we don't get to your question, please do follow up after the presentation. It's great to see so many questions, not terribly surprising given the nature of the topics we're talking about. And I want to move on and discuss the issue of drugs and alcohol in the workplace. And what I'm going to talk about first is a couple of cases specifically around refusal to test, refusal to submit to a test. And I'll do that quickly, and then we'll move into how that could interplay with an accommodation analysis for an employee using medical marijuana, and then finish up with a couple of cases dealing with employees who have substance abuse addiction issues, which is a disability. So to start off, I want to talk about, we went one too far. I want to talk about the LDI Mines case. And this is really a good example and a good reminder, and Allison touched on the phraseology, which is a one size doesn't fit all. And it's a good example of looking at a drug and alcohol policy and the employer applying their good policy, but an arbitrator deciding, well, in these circumstances, that's not exactly how I see things. And what happened here was, this was a palladium mine, one of only two in the world, apparently. And the griever was in a sense safety sensitive position. He was actually at the time in a bucket. So the bucket at the end of the machine that would sometimes dig and sometimes scoop, he was standing up in the bucket with another worker, and they were prepping the surface for blasting. They didn't have explosives with them, which is good when you hear what happened, but they were preparing the site. And some of you might be cringing, picturing two guys standing inside the bucket, elevated up so they could reach a surface 10, 12 feet up. Apparently common practice in the industry at the time. They don't do that anymore. What happened was this employee instructed the operator to tilt the bucket a little bit more because he couldn't quite reach where he wanted to go. The bucket was slick, it was humid in the mine. He slipped and he dislocated his shoulder. It was a pretty severe injury. So he went to the hospital and he returned to the workplace the next day for an investigation and follow-up. And because of the nature of the accident, slipping in the bucket, telling them to tilt it and falling, they couldn't rule out human error, lack of knowledge or skill. And so in the policy, that basically called for post-incident testing. And when the griever was asked to submit to post-incident testing, he said no. So under the policy, that's treated as a positive result. And under the policy, that then means you have to participate in a substance abuse referral program, a counseling sort of session. He didn't do that either. He did go to his own family physician, and his family physician applied a couple of indexes and sort of oral tests, I mean, like a questionnaire kind of analysis. And it was their opinion that he didn't have any addiction issues and he wasn't, inclined or heading in that direction to have any addiction issues. There weren't warning signs that there might be an addiction issue. And that was submitted to the employer. But the employer terminated him for failing to submit to the test and then failing to join their referral program. He was sort of on his own. He wasn't going through the process that was laid out by the policy following this accident. He asserted that the termination of his employment was excessive. In other words, that was too much. Was there something else the employer could have or should have done? And the arbitrator agreed and held that the context here warranted a lesser disciplinary response. It's important to note that the arbitrator decided that, agreed, went through all of the discussions I'm sure you're familiar with, that testing can be invasive and privacy issues. And the arbitrator agreed with all of that, but it was a safety sensitive position. And looking at the accident, the nature of the accident and what had happened, the arbitrator felt that testing was reasonably necessary and that the company had proper cause to test and that the company had proper reason to treat a refusal to test as a positive result and then require the referral program. So the arbitrator didn't have a problem with the policy. The arbitrator had a problem with the policy saying that meant you will have your employment terminated. He looked at it, he said this griever just suffered a bad injury, he'd been in the hospital, he was on other pain medication, he was asked right away to submit to this testing. He'd done testing in the past, you see here 40 years, he'd been at this for a long time. He had a lot of experience. So the arbitrator didn't consider it was really like him to not submit to testing. He'd submitted in the past. Bottom line, the arbitrator felt that this whole thing might have just been too overwhelming for the griever and that he didn't appreciate the consequences. So in the circumstance of the griever that was in front of this arbitrator, the arbitrator felt that termination was too much. It was too harsh of a response. In the end, the employer did really, in effect, get what they wanted because the arbitrator said termination was too harsh. What I'm going to suggest is, well, what I'm going to decide is that the griever will have to go through that substance abuse assessment that the company wanted, and he'll have to do that within 30 days. If that assessment comes back and says he's capable of returning to work, then he'll be reinstated. If that assessment comes back and says he's not capable of returning to work, then the dismissal will be upheld. So in the end, the employer probably got what it wanted, but this is, again, a good illustration of one size doesn't fit all. You can have a policy that says if you don't do X and Y, you're terminated. That may not hold up. And we have another example of, I guess, the perils of a policy. So the case I just talked about, the policy itself wasn't defective. It was, the arbitrator liked the policy, thought it was well grounded, but the application of it was that one step too far. In the next case that I want to discuss, Deering and Cougar Helicopters, the issue is that when you put your policy together, you need to live by your policy. We expect the employees to follow the policy and we hold them to it. You will also be held to it. So in this case, the employee was in the second lag vehicle of a two-vehicle process where they're towing a helicopter along the ground into a hangar to be worked on. And he's in the back, he's to be watching to make sure the helicopter doesn't strike anything. It struck something. He said that there was a flash or a reflection. They investigated right away, obviously, again, a situation where they couldn't rule out human error. And they wanted him to submit to a urinalysis test. And he said, no, I won't do a urinalysis test, but I'll do an oral swab test. And in his mind, he wanted the oral swab because he viewed an oral swab to be a better measure of current impairment, as opposed to the urinalysis, which he felt would pick up the fact that he had, in fact, smoked marijuana. And he said when it got to the hearing that he had smoked it 12 hours prior. He was a recreational marijuana user. It was not medical. He smoked a lot, and he said that he had not smoked within 12 hours of this shift where the incident happened. So he was wrong about what an oral swab will tell you. It doesn't measure current impairment, but that was his thought process there. When it eventually got to the hearing, there was and perhaps an even stronger reason, and this is what lawyers sometimes get slagged for, but he pointed to the policy. And he said that, well, the policy says an oral fluid saliva test, not a urinalysis. And so that's why I said no to urinalysis. That's why I said yes to oral fluid saliva test. And the arbitrator said, well, yeah, that's right. The policy does say that, and the employer has to follow the process that it set out. Even if it outsources the task and that outsourced company wanted to do it a different way, the policy said one thing. The other issue with the policy was that it said, it suggested to the employees that cannabis use might be permitted in the circumstances that he used it, because the policy said that an employee should not consume alcohol or mood-altering substances, read cannabis, within 8 hours from the start of the shift. So it's throwing out a time frame, suggesting to the employees 8 hours is your window. In some of the cases I'll talk about in a moment, we'll see that that probably isn't scientifically supported, but in any event, that's what led him to make the decisions he made, and probably not surprisingly, he won. He won this case and he was entitled to significant damages. So the lesson here is when you develop your policy, you're going to be held to it, and held to it in specifics, and also held to it in the message that it's reasonably sending to your employees. Okay, so you could try to explain that you meant something different with mood altering substances within 8 hours, but it's certainly reasonable, if you're looking at the language on the slide, that the employee thought he might have been permitted under this policy to smoke marijuana as long as it wasn't within 8 hours of his shift. Now, a case that many of you might be familiar with, the IBEW Lower Churchill case. And this is an interesting case because it's been heard several times now. In other words, first instance, and then it was reviewed. And now we have recently released the decision from the Court of Appeal in Newfoundland dealing with this case. We have an employee who has a need for medical marijuana. He has Crohn's disease, and he uses marijuana to manage his pain. And the lesson from here is, again, that the employer has, once you get past that first stage of establishing a prima facie right to an accommodation, the employer will have the burden to show that they have taken all the steps required up to the point of undue hardship to provide a reasonable accommodation. So this case, as I get into it in a second, is a reminder of that heavy burden on the employer once that first part is passed. So again, this was an employee who had Crohn's. He would vaporize marijuana in the evening, and then that would help him with his pain through the next day. He was working in a very large construction site with many different contracting companies. He had been on the site for quite some time with a different contractor. That engagement came to an end, and he applied with a new contractor for a position. And he was required, as part of that onboarding process, to submit to a satisfactory drug and alcohol test. He said, well, that's going to come back positive because I have a prescription for medical marijuana. They rescinded the offer, and he considered that to be discrimination. All the positions there were safety sensitive. So he said that your failure to hire me was a breach of your duty to accommodate me. Now, at the first instance, when it was first heard, that grievance was dismissed. The employee lost his case. There was no breach of the duty to accommodate. Why? Well, the arbitrator looked at the case, and there was medical evidence called on both sides. And the conclusion the arbitrator drew was that there was a lack of consensus in the medical community as to how to measure impairment or the residual effect of marijuana that next day. So he'd consumed it in the evening, what might be happening the next day, and the medical called in the case had put a range on possible impairment between 4 hours to 24 hours. And so the conclusion of the arbitrator, perhaps rationally so, was there is no consensus or ability to measure his impairment that next day. So how could it be safe to put him back to work? It's clearly undue hardship. So in the absence of an accurate means, then the health and safety risk was not something the employer had to take, and it was undue hardship. That was judicially reviewed by the union on the behalf of the employee, and that was also dismissed. In other words, they agreed with the arbitrator. Now it came to the Court of Appeal. So 3 judges sitting on a panel, and 2 of the 3 judges allowed the appeal, and they sent the case back down to an arbitrator. The basis on which is that they said, okay, because there's an absence of a reliable and perfect medical or scientific test that will let you know about current impairment, it doesn't mean your responsibility as an employer has ended there. It's almost, you could probably phrase it as the reverse of what I indicated in the first set of cases, where an employee was just looking for what's perfect as opposed to what might work. And so here, this wasn't the way the judges put it, but I'm trying to explain it because frankly, I thought the dissent was rather compelling. The one judging went the other way. But I think what the judges are really saying is your expectation that you need a medical scientific test that's going to be on or off like a light switch is asking too much. You didn't consider, and you need to consider, other individual ways of assessing this employee and their ability to function on the job. So this is what it's meant by, they talk about individualized daily or periodic testing. Could they do a close supervision of the employee? Is there a way to do functional assessments of him? And they quoted from the Supreme Court of Canada, and they said that the employer's onus here, what the employer needs to show, and I'll quote, is that it could not have done anything else reasonable or practical to avoid the negative impact on the individual. So what the two judges who sent it back said, we need to see you as the employer explore all your options in terms of that, again, close supervision, interviews at the start of the day to see how he's doing, or some kind of functional analysis. And largely because that wasn't done, it got sent back down to the arbitrator for the parties to call evidence and have that argued. The dissent thought that was just inevitably come back with no ability to measure current impairment. He had a set dose, but he's administering it himself. That type of consistency and the ability to know that, well, because he's great on Monday, what's it going to be like on Wednesday? It just didn't seem realistic to the dissenting judge. We'll have to see what happens with this case if the employer tries to get leave to the Supreme Court of Canada, and if they agree to hear it, or if it goes back down first to the arbitrator and we get a further decision on this issue. But it's a case that a lot of people were talking about, and we'll continue to monitor for you. Just as interesting and is the situation of how to handle, from a human rights perspective and a duty to accommodate, an employee who has a substance abuse disorder. They're an addict. And what does that mean for your responsibilities to accommodate? Because it is a disability. Okay. And these cases that I'm going to talk about are important. I mean, they're both from the nursing context, which is obviously a very safety sensitive, it's a significant context where there's a lot of concerns about the patient health, for example. But the principles are important to remember now because they might be a little bit different than we've thought in recent years. Specifically, we'll start with the Cambridge Memorial Hospital. As long as that protected ground is a factor in the decision or the discipline, then it could be discrimination. And again, equal treatment isn't the answer. A one-size policy isn't the answer. So what do I mean by that? In this case, we had a nurse who was terminated for narcotics theft. She had had surgery, been prescribed Percocets. She became addicted in that time frame. She lost her husband. So this was her story, and I don't mean that pejoratively, as to how this addiction had developed. Not mentioned very much, although I thought it was rather important. It turns out that she'd actually, in fact, been doing this for many years prior, and she only admitted to this as they found more and more information. I don't think she was being entirely honest, but in any event, that gets lost in where this case goes. And it is important to note the arbitrator here did say in the decision that but for her addiction, she wouldn't have been taking these Percocets. Or stealing the Percocets is what I mean. And so the arbitrator still went on to uphold the termination. And basically, the reason for doing that is that, because there's that connection between the addiction and the misconduct, that can't just be a defense. And that was the sort of argument or analysis that we would see. There was a case we've talked about in previous seminars a few years ago where an employee had stolen a bunch of copper wire and said, well, I had to support my cocaine addiction. And that excuse did not work, and the employee's termination was upheld. So that's the similar sort of approach here. And secondly, that the policy is on its face neutral. The employer applied this policy, termination for theft of narcotics and falsifying records across the board, applied to everybody the same. And that's really one of the lessons here, is that is not the way that you can approach this type of an analysis. It's just because the policy is the same for everyone, that's in fact the problem that I was speaking of, where you can have an adverse impact. It's harder on the person who has a drug addiction to comply with that policy. The consequences on that person are more significant. And so you're going to engage that accommodation analysis. And so the court said, you have to engage in that analysis, and overturned the arbitrator's decision, said you didn't apply enumerated ground, an adverse effect, and a connection between those two. And that's the arbitrator's language, that but for her addiction, she wouldn't have stolen these Percocets. That establishes the prima facie case. So now you have to consider your duty to accommodate, and the employer didn't do that. And so they lost their case. A similar analysis is in the regional municipality of Waterloo case, and it goes a little bit further to put some more explanation to the concept I just discussed, which is that the employer has to conduct that sort of individualized assessment regarding the impact of the substance abuse disorder. So again, we had a nurse who was stealing drugs, and the employer found this out and terminated her for theft of narcotics. A hard decision. You didn't engage in a discussion about possible accommodation or what could be done to get the nurse back to work, or would that be possible? They said, no, this is a terminable offense, and that's what our decision. When it got to adjudication, there was evidence, medical evidence, that demonstrated that the substance abuse disorder here was causing compulsive behavior. It was resulting in impaired judgment on behalf of the employee, and that's what was contributing to the theft. So there was a connection as to the disability and the outcome. In this case, because it wasn't until it got to the hearing stage that the employer was then saying, well, we can't trust her. Trust is the bona fide occupational requirement, and it would be undue hardship to not be able to have that level of trust. There was discussions and evidence about relapse rates. But essentially, again, this is a situation where that was really too late in the process. The employer had not, because at the outset they had not engaged in much of a discussion or analysis, they hadn't looked carefully at the College of Nurses, who obviously controlled the nurse's license to practice and had now set up conditions for her ability to return to a workplace. It wasn't specific to this workplace. But the employee had completed treatment, a long course of treatment. And so it was really that, again, consistent, determinative application of a policy and a terminable offense for stealing narcotics, without realizing that that is still a prima facie discrimination. The causality between the disability and the misconduct raises that discrimination analysis, and you now have to consider your accommodation. And that could have been done by engaging with the college or looking at their restrictions and requirements, and they hadn't done that. So both procedurally and substantively, the employer had fell short. And a lot of this came from some decisions, if you look at a decision out from the BC Court of Appeal, that is not being followed in Ontario by the arbitrators. And so the nurse was reinstated with back pay. So takeaways on drugs and alcohol is that, remember, a refusal to submit to testing or post-incident testing might be disciplinary, but it won't necessarily justify dismissal. That's the one-size-fits-all context. Again, what language you have in your policy will matter because you will be held to it. You may need to explore other means of accommodation and assessment if the employee is using a substance that could be impairing. So this is that case with the fellow who was using medical marijuana the evening before. The fact that there isn't a scientific test that makes it easy is not a full answer on part of the employer. There could be other methods with which they could decide how the work might be done safely without suffering undue hardship. And that's to the last point on that slide as well. So just because there's an inability right now to determine current impairment with some level of precision, it doesn't automatically mean that that's undue hardship in a safety sensitive position. So the case law is now settled in Ontario that you have to consider possible accommodations if there's a substance use disorder. Those are the last two nursing cases that we talked about. If it's a factor, i.e. but for this she wouldn't have, or evidence about compulsion and impaired judgment, that will engage the analysis, and now you have to consider what your options might be. We talked some about the college involvement, or do we have to give them a leave of absence for treatment? Do we ask for a last chance agreement either after treatment or upfront? And that is a whole topic unto itself, but you need to take that step and you need to go through that accommodation analysis, because that first part on establishing the prima facie case is established in those circumstances. So we do have a lot of questions. We're going to do our best to get to as many of them as possible. And as I indicated, if we don't get to your question, just please follow up with us. And I'm going to let Allison handle the first question.
So good morning again. And yes, we do have a lot of questions. So I've tried my best to start with family status questions sort of by category, because a lot of them were related. So if you don't hear your exact question, hopefully we get to the topic anyway. So one of the groups of questions we're receiving is, if an employee has a family member at home, so a parent, a young child not in school, a sibling, etc., who has a medical condition that puts them at higher risk for contracting COVID-19, would this be considered under the family status accommodation? Well, the first thing is it may be if there's that caregiving relationship, so that's similar to parent-child relationship. So the child needs to be at home, for example, to receive homeschooling. However, if there is somebody who's just living in the household, then you might need to consider whether or not there actually requires an accommodation. And this links really well actually to a second question, so I'm going to answer them together, which is, how would you suggest managing an accommodation request to work from home due to the fact that they live with a medically vulnerable person, such as a senior parent? So in this case, what you really want to be looking at, first of all, is there even a duty to accommodate? Because if the employer's putting into place safety protocols to reduce transmission risk in the workplace, then maybe there isn't actually any need for accommodation. If they're not coming into contact with other people, if those protocols are actually quite stringent and safe, then is there really a duty to accommodate? Maybe not. So that's going to depend a lot on the nature of the work, the risk of transmission at work. So again, like how many people do you come into contact with? How many high touch surfaces are there? The medical condition at issue. Does their parent or child or sibling, whoever else they're living with, have a serious medical condition? Is it a fairly minor medical condition? You also want to look at the risk to that population and whether the employee or that other person is actually able to self-isolate in the house. Because just because they're living together doesn't mean that there's necessarily accommodation required. If that person in the house or the employee can self-isolate away from each other, and that employee is in a workplace that doesn't require a lot of interaction with other people, and they can also be fairly safely kept relatively isolated in the workplace. So this also leads to a couple of other questions that were along a similar bent, and they are all excellent questions. So we had a question about whether the parent-child definition extends to in-laws. So to clarify, although parent-child is generally parent-child, although of course it doesn't need to be a biological relationship, there are circumstances where adjudicators have found that it's similar to a parent-child relationship. So maybe you're the grandparent, but you have the primary caregiving over the child. Or maybe you're the aunt or uncle, but the child's come to live with you. So you are the primary caregiver at that point in time, and it's like a parent-child relationship. What you're really looking for is a similar relationship in terms of care, responsibility, and commitment to that child. So there might be circumstances where it's not exactly the parent-child, but the in-laws, for example, could actually claim family status on the basis that they are the primary caregivers or they have that caring relationship for the child, and it will depend on the specific relationship. Another linked question we had there is if an employee refuses to return to work because of her concerns about getting COVID, as she visits her parents regularly and her parents have some illnesses, should we accommodate, knowing that the real reason for her request is that she wants to work from home permanently? And you do get a lot of these questions in these situations. So the first thing is we're assuming it's her choice to visit her parents, but she is not responsible for their care. If that's not true, it's a different situation entirely. But if it's her choice to visit her parents and she's not responsible for their care, then it's the duty to accommodate might not be triggered. And that needs to be very carefully looked at in terms of, again, that sort of caregiving relationship and whether this is actually a choice or a necessity. To move on to sort of another group of questions, we have a bunch of questions, and I think, again, they're very good questions about the protected leave. So that's the infectious disease emergency leave. And so one of you has asked, is it a protected leave and how long will it exist for? So yes, that infectious disease emergency leave, I will get this right at some point, is protected. And they can access it as long as they meet those conditions and as long as COVID is a designated infectious disease. So you have things like SARS, which at one point in time might have been a designated infectious disease. COVID's a currently designated infectious disease. If it's no longer a designated infectious disease, they don't have access to that leave. Similarly, we have questions about what are the considerations for approving or denying that unpaid infectious disease emergency leave for employees who are caregivers or living with high-risk family members. Can we ask for medical documentation? And what is the reasonable periodical review of the leave? So again, the consideration is really whether it's that care and support element. Are they needed to care and support for that family member? With the unpaid leave, you cannot ask for medical documentation. So that's an important point and one we want to make clear. No medical documentation for the unpaid leave. And the employee is entitled to this leave under the Employment Standards Act, which is also, again, different than accommodation, which they may or may not be entitled to.
If I may jump in there, Allison.
Of course.
We have a lot of questions on that particular issue, and it's not surprising. So Allison has talked about that unpaid leave provided under the legislation. So that's covered off, and you cannot ask for medical. That's part of the legislation. It is a different question, and it's a different analysis where they're talking about an accommodation. So for example, that category we just discussed about someone who now wants to work from home. So you absolutely can and should ask for you should ask for a medical to support that, and then you have to consider, okay, what are the accommodations that we can offer, and sort of distilling some of the things I'm seeing in the questions and giving some advice as to where I think the answer is for that. Some of the basic concepts that we've talked about before with respect to accommodation apply. You don't have to pay someone to work from home if there's no work to do. You don't have to create a new job if you don't have a job. I think, we are in a different sort of pandemic, we're in a different world right now. And so we might not be able to be so blunt about those things. There might be some reallocation of duties, or we might have to actually think hard about, well, can this job be done remotely? Are there some changes we could make to do that? So I think you have to give a good faith effort to it, but there are still some basic principles. You don't have to, you are entitled to get useful work back for what you're paying. I saw questions in here about employees whose performance is declining, and so we need them to come into the office. And I think that is, again, it's a situation where if we're talking about a small dip, you might have a harder time. If it's clear and you could explain, well, for example, this employee runs payroll and they need to be in the office in order to process documents more efficiently, be able to ask questions and be available to other persons in the office more readily in terms of getting all of this done in an efficient way. So if you can establish that need, then you're in a different position, in a better position to explain why the physical presence in the office is an occupational requirement. And I think just because you got by and you made it work in March and April and May, that'll be part of it. It's definitely some evidence, but I do think it's a fluid situation. And a lot of us were just getting by in March, April, May, June, July even. We were just trying to get by and make it work. And certainly the expectation can't be that the standard is just that employers need to get by. We want to run our businesses efficiently, safely, and profitably, frankly. So another question that came in was with respect to an employee who might be, so I'll read you the question. Can an employer dismiss an employee who is addicted in a different way? In other words, dismiss them in a different way. Dismiss them due to budgetary restrictions. So the short answer is yes. The important answer is you need to look at the situation and know and be able to prove that your basis for terminating this employee is not related to the disability, okay, the addiction. So if it is a legitimate budget issue and you have to reduce numbers, fine. But you will also probably have to explain why that employee was one who was reduced. It depends on how many are reduced. Just be prepared that you would have to answer those questions, because it wouldn't take much to think of the right questions to ask in terms of whether or not the disability played any part in that decision to terminate. So, if the employee had performance issues that weren't related to the disability, that's helpful. But if the disability played any part in the decision, the selection of that employee, then you are at a material risk of a human rights finding. Allison.
Okay, and so to come around to one of the other groups of questions I saw, which is really if there is a parent with a child who cannot return to school due to COVID, what exactly can you ask in terms of medical documentation? Which is a very good question. So what you're looking for here is not necessarily documentation about a diagnosis. You're looking here for medical information that talks about the fact that their child cannot return to school, so a confirmation of that, and also possibly about restrictions and limitations. So why can't they return to school? But again, that doesn't necessarily mean a piece of paper telling you the diagnosis of the child so much as what are those restrictions and limits and confirming that they cannot attend school. I had a question actually about a specific slide, which I think we should address. And that's about the parent choosing to keep their child at home. And I realize this might be a little bit confusing. So the question reads, if remote learning is an option and the parent chooses this option, they are entitled to unpaid leave, correct? You are correct. If remote is not an option as given by the school, but the parent chooses to homeschool, then they are not entitled. Not quite. So I think the issue is whether or not there is a choice. So if you choose to keep your child home, whether remote's an option or not, if you're choosing to keep your child home due to COVID, you have access to that leave. The difference for the human rights accommodation is when you're looking for that leave not to be unpaid. So you're looking for a work from home accommodation, or you're looking for a paid leave or something like that. Maybe you're looking for different hours, maybe it's some other form of accommodation. The difference is the infectious disease emergency leave can be accessed if it's your choice, but it is completely unpaid. And so when you're talking to someone about what they're looking for and they're telling you they're choosing to keep their child home, then that infectious disease emergency leave is something you're talking about. But if they're asking you that they want to work from home, that's an accommodation issue, not an unpaid leave issue. Because if they're unpaid leave, they're not working. I'm going to turn it back over to Brian momentarily.
The moment is now. Some more accommodation questions. So one question, does accommodation have to be in the same job or position? No, it doesn't. I think that's a starting point. If the employee can be accommodated in their same position with some modifications, then that's sort of the first avenue that you should look at. However, if that's not possible, the sessional duties aren't going to be covered off, then you might have to look to other positions. Again, as I mentioned, you don't need to create a new position, but bundling of duties is sometimes what some people will do. Another quick point as an aside is that if sometimes collective agreements have particular language, but if someone is being put in an accommodated position and that accommodated position has a different rate of pay, unless there's some provision in a policy or a collective agreement, you're not obligated to pay them at their old rate for their home position, so to speak. You could pay them for the work that they're actually doing, which is a concept I mentioned earlier. Can you still performance manage someone who's on accommodation? Absolutely you can. But you need to take into account what the issue is that's being accommodated in your performance improvement or performance management. So the easy example, but important, is someone who has a physical disability or any form of disability that makes them work slower. You would have to incorporate that into your performance plan. You can't put the same expectation on them as another employee unless you're prepared to then take that and prove that that's a bona fide occupational requirement and that they can't do the job at 90% or 85%. Otherwise the system breaks. So you just need to make sure that the disability is not directly related to the performance issue. What if an employee provides documentation from a doctor that states that they have to work from home due to a medical condition? What does the employer do in this circumstance when they're required to work on site? And we're talking about an essential service or residential property management. So, you know, this is, it's a situation where you're just going to be put in the position of explaining why they have to be on site. And if there isn't work that can be available and performed from home, then that's the end of the analysis. So as long as you've investigated that possibility and you have a strong answer as to why that is not possible or won't work reasonably, then that will be the end of that analysis. We also had a question specifically about the case where the minor fell in the bucket and then went to the hospital and came back and didn't want to do the test and didn't want to do the referral program, and then the arbitrator said, you shouldn't have fired him. I think that, so the question was, well, in that case, the arbitrator liked the policy but not the application. If the employee was not tested immediately for post-incident, how does the employer know if they were unfit for duty at the time of the incident? And you're correct, they won't get that answer in terms of their level of, I mean, this gets wrapped up in all of that science about what's in their system and did that mean they were currently impaired or not? And that the bottom line is that could be a question that just doesn't get answered by the science and the medical, despite what the policy says. The arbitrator did like the policy, and again, it's information that's provided to an employer as to what might have caused an accident. But I think if I was to try to wrestle that down and explain it, the real important piece from that case is that where that policy led someone on a failed test or a refusal was into that referral program. So they're pulling out, is there an ongoing addiction issue at play here? Is there an ongoing substance abuse issue going on? And that's where the arbitrator got to anyways, and that's where the policy would have fed it. And that was really sort of, frankly, what the arbitrator felt was the more important part of this policy than strictly determining the cause of that particular accident. So I think that's the best way I would describe that case. Alison?
Okay, so I'm going to address two more questions here because I think we're getting into the more situation-specific ones, which are equally interesting to talk about. So somebody's asked, a retail employee who is a parent has requested adjusted hours so they can drop off, pick up their child from school, as they don't feel it's safe for the child to take a school bus, which is available because of the fear of COVID. This wouldn't be considered a need, would it? From what we can see, just on the basis of this does sound like a preference rather than a need that would trigger the duty to accommodate. However, we would suggest, of course, that you ask all those sorts of questions about what is going on and what's this based on, just in case there is actually a human rights issue. Secondly, we've got, if an employee requests to work from home because she chooses not to send her child to daycare, can we ask her to use vacation and personal time? And then once this is exhausted, she can go to emergency leave. You can certainly ask, but there's no obligation for your employee to do so. If they ask for the unpaid emergency leave, they are entitled to it, and they are not obliged to exhaust all of their vacation and personal leave time before so doing. So in that situation, again, maybe it's something your employee is open to, but if they're not open to it, then it's not something you can require them to do.
So I had a couple more questions on the accommodation piece, which is perfect because that's what the topic was. So the question was, what if an employee gives a medical that doesn't give all of the details the employer needs? Can the employer ask for more detail? And the answer is yes. And that's illustrated by some of the cases that I talked about where the medical that was coming in, frankly, didn't give the employer the kind of information it needed. And I'm talking specifically about the Canada Post case where they said, well, try this other route at this other depot. A quick aside, I think there was another question there about how many times had Canada Post proposed different routes. I think my understanding of the case was just the once, but the point from that case was the employee didn't come back and say, well, that's not going to work because. So if I thought about a more recent and specific example, I had an employer who got a medical note that said the employee could not work Saturdays or Sundays. Some level of suspicion around that, largely because we had a sense that the underlying disability was an anxiety, depression kind of thing, but what's the deal with Saturday and Sunday, because the medical note had not explained why. So it was a situation where we wrote back and the explanation was that there was a particular wellness program on Saturday, which turned out was yoga related, and a religious program on Sunday that this person had to attend. So of course you can understand why that might lead to more questions. Well, are there not other religious programs that could be attended on other days of the week, et cetera, et cetera. So if you see something that's not answering your questions or giving you a direction, or it leads to a legitimate other follow-up, then absolutely you can do that. I think what I would say is be very careful that you're approaching it honestly and in good faith and not just trying to be difficult. But believe me, there are plenty of circumstances where a medical note leaves questions to be asked, and it is appropriate to do that. I had a question about one of the slides earlier regarding the commuting issue. So does the employer's obligation to accommodate extend beyond the essential duties of the position and then include a commute? So in that particular case, that and for recollection, we're talking about that school board case where the teacher couldn't drive more than 30 minutes. So the short answer is yes, that the decision basically said that that's about getting to work. And if there's restrictions about getting to work and the employer has other work sites that might relieve that adverse circumstance, then they could be required to accommodate. So I think, if I'm putting it bluntly, when you read that case, I don't think they were trying to set a very clear message that that will always be the circumstance, but they're saying rather there could be circumstances where that will be relevant in terms of their ability to get to work, and you have several different work sites. So what can be done to help the employee around the adverse circumstance? Alison, do you have any questions?
I do. So I have two more I'm going to address. The first one being that one of you said, I have a number of employees on maternity leave who are concerned about returning to work due to the lack of childcare, and understandably not knowing if childcare will be an option when they return, depending on a second wave of COVID. We will do our best to accommodate with flexible work hours, working from home, etc. If they are unable to return to work at all, would the best option be to allow them to go on a protected unpaid leave of absence? So if the employee has established a need for accommodation, so they're unable to get childcare despite their efforts to get it, and there's no other paid accommodation that could be given, then maybe a leave of absence is the only available option. So you will have to, however, have considered paid accommodation first. So you'll want to exhaust all of that, flexible work hours, working from home, anything else that can really be dealt with in terms of paid accommodation. If all of that has been looked at and it's not possible, then you might be talking about leave, but a leave that's not necessarily under the Employment Standards Act. And that might be an accommodation under the employer's Human Rights Code obligations. So remember, we've got the infectious disease emergency leave, then we're talking about human rights accommodation. And if you're talking about human rights accommodation, then you might be talking, including under that accommodation, about a leave, which is not under the Employment Standards Act, but is a leave for human rights accommodation reasons. I realize that can be a bit complicated. If you do have any questions, please don't hesitate to reach out to us because, as I said, I know there's a lot of things happening here and it is a little bit of a complicated concept. Second question I'm going to address is a family status accommodation for staff who was full-time to work fewer hours, which makes them part-time. And the question is, if we accommodate, do we have to guarantee the same full-time rate of pay if they're now working part-time hours, or do you pay the reduced rate of pay? If the only accommodation is reduced hours, the employee is entitled to compensation for the job they are working, not the job they performed before the accommodation. So if it's a part-time or lower paid role, they'll be paid at that part-time or lower paid role rate. But you would, of course, want to have checked before this if there was any other type of accommodation that didn't force them into a lower salary rate beforehand. Brian?
We'll take a couple more questions and then we'll call it at our 10:30 time. And again, please do follow up with the questions that didn't get answered. We've tried to bundle them together where we could. I do want to, something that we've touched on, but I do want to be very clear. So again, we've got the question, what if the employee is stating that they're working from home remotely in an efficient way? They don't see the need for them to come and work from the office location. So just to be, again, very clear about that, it's not the employee's choice. Okay? Unless there's an engagement of human rights needs, so the medical issues or the childcare issues that we've talked about, in which case you do have to consider your accommodation responsibilities. Unless there is that status supported by medical, then you are not required to reconsider whether the person can work from home. Now, I would say, like, of course, this is the lawyer answer. So the other piece of it is maybe you want to start considering other types of arrangements, or maybe from an employee relations perspective, you want to consider moving to a different scheduling or permitting some to work from home. Maybe that raises problems for you that you don't want to deal with in terms of employees competing with each other or not being satisfied that so-and-so has a particular arrangement and they want something similar. So of course, there could be any number of difficulties. So from the legal answer, it stops, and it can be your decision unless there's an accommodation issue that's raised. Otherwise, you're playing in the sandbox of just deciding whether that's something you want to consider or not, but there's not an obligation to do so. Lastly, there was a question about, as an example, an addiction center. And I picked this, although it's specific to that context, of course, it illustrates some of the principles we've been talking about again. And in this situation, in that addiction center, the workers there are themselves in recovery. So they're recovered addicts themselves. I'm going to read a little bit into this because what's set up here is that if that person is not in recovery, then they would usually be asked to go home, or they'd be removed from the workplace. I take that to mean that they're not sort of participating in their follow-up and their recovery process, and so you have no confidence that they might not be using again, for example. So it is now, it's very clear if you look back to the cases that we've talked about and that analysis, we do have a situation here where the addiction, the disability, is causing the negative impact. In other words, is their addiction, where you're imposing on them the standard of being in recovery, and they may not be in, and so you're saying you can't work. So now you have to establish that decision as bona fide, and you have to establish that that decision can be supported up to undue hardship. Now, are there cases specific to that? Not that I'm aware of, but there are certainly plenty of cases that talk about substance abuse in the workplace and bona fide health and safety support and needs. In fact, the cases that I talked with respect to the nurses are two examples. I think that you would probably want to explore the rationale for having that requirement, that they have to be in recovery. And again, I'm putting a little into this. You're obviously the expert on your workplace, but I would think that an inability to know that they're following their recovery process, they have the supports, and that they're not using, is likely supportable in that context with that client group where you're the people that are there that you're servicing are addicts in recovery themselves. And I would also imagine that that's in fact one of the reasons why you select employees from that pool is the connection and the understanding and the example that they set. So that's what I would say to that. So we're past our time now. We are going to wrap it up. We thank you very much for attending. Our next HR review is going to take place on Wednesday, December the 2nd. The topic is in the design phase, but as soon as we know what that is, we'll send out our invitations. If you're on our mailing list, you will get that invitation and notification. If you're not yet on our mailing list, then you want to receive our briefing notes, our newsletters, or invitations to the seminars and workshops like this, and more specific topic-focused workshops, then please subscribe through our website. So thank you again, everyone. The turnout was fantastic. I hope you found it helpful. Please have a great day, and please stay safe.